Thank you, and hello everybody. I want to start by thanking Rafael for the invitation. I'm delighted to be here. This is a great opportunity not only to share the Ecuadorian jurisprudence, but for me to learn as a lawyer, as a person, as a convinced person of human rights and rights in general, and also as a judge. This is the chance for me to hear you out. So I'll really invite you not to talk about the good things of the decision, but try to criticize it and find the low points. I deliberately put some slides to give you a little inspiration on that. And I really want to share with you the process of the court. And to get to the Estrellita decision, we had to walk a long course. And after hearing my previous colleagues as judges, the first thing I think I need to say is that maybe one of the things the Constitutional Court of Ecuador had to learn was that the Constitution has a lot of things that needs to be developed, but we need to be precautious. And as I talked to a former constitutional federal judge in Germany, Susan Baer, she uses the term proportional courage, which means you have to have the courage. The courage is necessary for judges to go to this kind of decisions, but this courage has to be proportional. And even though you have the need to say, and even though you have the chance to say a lot, sometimes you have to say less to make sure that you can prepare the territory. And just before we were hearing it's necessary not to be perceived as so radical that maybe it will be taken in the wrong way, and maybe you will get people to be against the decision, but if you go a little bit slower, sometimes that's fair. I begin with this because sometimes, and one of the critics in Ecuador, it's like, why if you had the chance to say, why if you already had the case, why did you let some things unsaid? And sometimes we as judges are supposed to leave things unsaid. And sometimes we have to recognize that even though if the parliament is not the better place to do that, the politicians are the ones who are supposed to take some of the decisions, and we are supposed to just frame the field for them. So in this matter, we have done that as well. To begin with, the overview of this presentation, I'll talk about the nature's rights in Ecuador. Then we'll go to the previous constitutional jurisprudence. That's the one that framed the field for Estrellita's case. And even though I know you're looking forward to hear about Estrellita, I really think this is a chance to see how was the approach in Ecuador, where is it coming from, and maybe it will be a nice proposal for your work, for your ideas, to get some perspective from other contexts like Ecuador, where we have a very protective constitution. By the way, we have 444 articles in our constitution, so it's a really big one. It says everything about everything, and you will see. And you have articles to choose whether if you are progressive or you're conservative. It's everything for everyone. So if you go to the preamble, since the preamble, the Constitution of Ecuador talks about nature as a vital part of our existence. When you see the Pachamama, that's a word, that's the way indigenous people call nature in Ecuador. And the Constitution of Ecuador begins with the recognition of that Pachamama as part of our existence, and it says that we are supposed to live in harmony with the Constitution. As part of it, in Ecuador, we have something called the summa causa. This is the good way of living, and it's part of like when you talk about the American Constitution, you talk about happiness and liberty and equality, or in the French case, for us is the way good of living. And that way, a good way of living involves nature and involves indigenous communities and involves their practices over nature. So that's like the main thing in our constitution, to talk about environment, that's the frame. Then, since Article 10, you will start finding that in the Constitution of Ecuador, we have nature as a subject of rights. And nature is called like that in the Constitution, and the Constitution recognizes that nature should be subject of those rights, and I'm going to get back on this later, but this is important, subject of those rights that the Constitution recognizes it. And then you have a whole chapter for nature. That's chapter 7, where the articles 71 to 74, and these articles talk about the rights of nature. And the first right of nature is to receive an integral respect for the existence, maintenance, and regeneration. Then you have a second right to be restored. And then you have these obligations, they are like 3 really specific rights. And then you have these obligations from the state and for the person and the communities, not only to prevent, but to fix it when something is damaged. And it gives them, I couldn't put it in, I didn't have any more space, but every person in Ecuador is supposed to take care of nature and has the right to present actions administratively or jurisdictional actions to protect nature's right. So we have the chance. You don't have to be part of the environment. You don't have to be in the zone. You can be wherever you want, in a bank, in this capital city, and you're still entitled to present actions on behalf of nature. But here, you will have another right that it's gonna get in conflict, and I'll show you how. It says that persons, communities, when I say communities, I'm talking about indigenous communities, okay? Because Ecuador has a multiplicity of nationalities and different communities, indigenous communities. People, nations should have the right to benefit from environment. And we have a whole chapter about environmental rights of people, that includes, for example, the right to water, which is a really good development, and maybe it's the first country to say it in the Constitution, the right to water. And so we will have a whole chapter of environmental rights that are going to need to coexist with the other stuff we talked about first. How does this work? As I said, the path the Constitutional Court has traveled in these few years, the 4 years I've been in the court are the ones we have worked all this. There's only one previous decision in 2015, I think. And the thing is that nature was in the middle, but as you can see, the Constitution of Ecuador is really general, and the nature's rights were seen as a universality, but they never got content. In these last 4 years, the Constitutional Court started to give content to all of those nature rights. And it started by working on different ecosystems. First, some rivers came. We have two decisions about rivers, Rio Akepi and Rio Monjas. Monjas is in Quito, actually, in the capital city. And then we talked about mangroves, and this was really difficult because shrimp are involved in this, and that's a huge industry. It's probably like the third product that Ecuador exports to the world. So you can imagine how many interests are around it. And then we have forests. And this forest you have there is Los Cedros, and that case is related to mining projects. So you can now figure out how many interests are over there. And so we were trying to give content to all this nature stuff, and the last of our decisions is in Estrellita for the animals. But this Estrellita case needed the other cases to be possible. Estrellita was not the first attempt. Estrellita it wasn't something that we just woke up and saw the chance of getting there. It was the result of many steps before. And these decisions that I'm gonna tell you about first are really important to understand how we were building the path to get to Estrellita. About the rivers, those are the actual rivers. The court started saying, okay, rivers have the right to be preserved. They are supposed to keep their structure, and they are supposed to be able to fulfill the life cycle. In these cases in particular, the allegations for the river's rights were related to the river flow. In one of the cases, the one in Ecuador and the one in Quito, the one up there, the problem was that they are putting all the, they use it to discharge the black waters of the city. And the problem is that even though they say they are treating the water, it's not only about contamination. And this was the first case that the court was not dealing with the contamination of the water, but the size of the flow. Because all this water going to the river is starting to change the flow. And it's so high that it's changing the environment around it. And it's actually putting in danger homes because it's taking all the caudal is too heavy. So they were asking for the right to of the river to preserve the normal flow. And on the other one, it was about changing the flow or using the flow. And they were using it so much that they were affecting the river, or they were trying and asking for permits to get to be able to change the flow of the river. So the Constitutional Court said, okay, rivers have rights, rivers are ecosystems, and nature cannot be only a universality. It's not something abstract, it's something that has to be determined. And this determination in the case of rivers is that rivers itself are subjects of rights. And then, obviously, it has to be able to fulfill its role in nature. And it has to be able to have this evolutionary process. Of course, when the court said this, everybody said like, okay, now they have gone crazy. And then we kept going on. And we got into forests. Some of this happened like in another order, but it's a better way. And when we got to forests, this forest name is Los Cedros. It's not very well known. It's not part of the jungle. It's part of a cloud forest. And they have so many living beings there. There are some organisms that you could not find them in other places of the world. and it's pretty unknown. And the government gave permission for mining projects over there. And so they filed a plaintiff against these permits, and they lost on the first instance. And then the Constitutional Court chose this case, and this was a huge case because we had to, again, say that, okay, we already said it with rivers, now forests are as well as an ecosystem, and they have rights as well. And here you have all of these life cycles working, and the court said when one of those elements gets damaged or gets changed, everything gets changed. And the ecosystem as a whole, it's going to be affected. And so we have to prevent that from happening. And here, one of the most interesting parts is that the court developed some principles that are really important in environmental law. The first one is the prevention principle. The prevention means that we already know the impact it's going to have. So if you already know the impact it's going to have, well, you have to stop that kind of development or production development on the forest. But there's another one that's as important, that is the precautionary principle. This means that you don't know the impact that's going to be on that ecosystem, but the risk is worth it. So you have to prevent any possible damage, even though you don't have scientific information that tells you that it's going to happen. In this forest, and I have to say I have a vote in this, I resent my vote because I was not convinced that it was real, that we don't know the impact. I was sure I knew what the impact of mining was going to be. I don't know why we are doubting it. But actually, the judge issuing the decision said no, because you can only think about the obvious damage, but not the real damage. And there is no scientific evidence that will let us know what is the amount of damage that is going to happen, and he decided to use the precautionary principle. And that's the first time in Ecuador that someone used that. And now you are supposed to, and authorities are supposed to take that into consideration to give permits or to give authorization for any production activities. And in this case, the court started to be we wanted to be careful. And we already said productive activities are permitted if they don't have negative consequences. And we discussed about this in the court. Like, is there any activity that's not going to be negative for the environment there? If that's such a special forest, everything is going to have an impact. However, the court was trying to be careful not to be radical. And it said, okay, maybe there are some things that can be done, but if you find or you see the risk of impact and damage, you should not do it. Obviously, the part who didn't like the decision said, you just ban everything because everything is going to damage the forest. So you said that you did it, but actually you did. So, but the court said it this way. And then it came the mangroves. And with this, we found a problem. Related to mangroves, we have the shrimp. And actually, one of the cases is related to a shrimp company that was using the mangrove to produce the shrimp. And the Constitutional Court, the main things, these are huge decisions, so I'm just taking the important part, said that the production and the consumption cannot become a predator a new predator for the ecosystem, that we have to find an equilibrium to allow the regeneration and maintenance, and that the economic system and nature rights have to coexist. Why did the Court of Ecuador say this? Because we have a chapter on economic development. And so if you go to Article 283, it says that the economic system is supposed to be oriented by supportive and solidarity and whatever, and it says that it has to go in harmony with nature. And so the plaintiff, the company, the shrimp company said, like, I'm only using my right to economic developments, and I have a right to work, and I have a right to sell my products. And the Constitution says I am able to do this, and the Constitution says that we have to collaborate and we have to coexist, and we have environmental measures, and we have a special department of like corporate responsibility, social responsibility. And so the Article 283, it's been used several times to say, okay, I'm not supposed to stop doing things, I'm just supposed to be in harmony with nature, and that means I can produce, I can work. And this has started to have to make a tension between one or two articles with each other and with the court. We were having tensions for all of this. And then, before I go into Estrellita, I know it's a lot of information, but I didn't want to miss anything. But after all these cases, we can conclude that we have some field already marked from the Constitutional Court. And so the nature is being recognized as a subject of rights for its intrinsic value. So we are already on the path of animal rights, right? And the court has said that it's an end in itself, that it's not an instrument, that it's not an object that the human can use to pursue their well-being. We already recognize that nature is made up of interrelated, interdependent, and indivisible set of biotic and abiotic elements that are linked and have functioned or role in the ecosystem. This phrase I just said in number 2 is really important because that's part of what allowed us to go to Estrellita. Because we already said, and everybody was aware of, nature has biotic and abiotic elements. And when one of those elements is affected, all the ecosystem is affected. And so the court, and obviously many people were not happy with this, the court said it's not nature as a whole, it is, but it's not only that, it's also nature as determined holders. And these determined holders can be ecosystems, like rivers, like mangroves, like forests. And we also established some criteria to say when it is okay to use nature resources in a legitimate way. And we said, like, okay, it aims to guarantee a good way of living, but without jeopardizing the future generations. The method, the action has to be the least harmful measurements. The greater degree of non-satisfaction, this is like the proportionality test, that we did it for nature, to make sure you are taking the best measures to guarantee nature. And then we said something that is really important for Estrellita as well. There is no need for jurisdictional recognition of each of its components to affirm that it is a subject of protection. And you don't need, because the Constitutional Court started saying we have an open clause. Why is this relevant? Because I read it in the first slide that the Constitution says the rights that the Constitution recognizes to nature. And most people think that that's only Article 71, 72, 73, and 74. And the Constitutional Court said, no. It's an open clause. Because you need different rights to get to the protection. And we cannot just stay in this clause, closed or taxative, exhaustive clause, because we need some more. And then nature needs some flexibility about rights to make sure you can protect it. And that was a really good thing to go to Estrellita. And finally, the other thing, the important thing, was that reparation of the damages, and the Constitution says that every judge that finds a damage or a violation of a right, of nature's right or whatever right, you have to reparate that. You have to fix it. And you have to leave it as before. And for so, the court said, how am I supposed to repair it if I don't know the determined holder of that right? How can I fix nature if I don't know who's the one I have to fix? So it says, I need to identify. I need to know what the specific nature's component is the one I have to repair. So it's not wrong to say that we protect nature, but nature has a lot of components, a lot of elements, and I can protect them individually, even though the Constitution talks only about nature. So then it came Estrellita, and this case gave us a lot of work, and let me start by saying that I don't speak animal law language. We were beginners in this. We were working our way on the environmental world, and suddenly we got to this case. And as the judge before said, like when we got this case, in our case, it was a case we chose as a court to develop jurisprudence. But when we got it, we were like, oh my God, what are we going to do with this? And let me tell you some backstages of this. The discussions were really hard. And this decision made really huge developments about what you've been talking the whole day. But for us, it was something amateur. We're not into this. And we had to learn about this. And I'm sure we have a lot of mistakes. But the thing is that the court started by saying, okay, we just found another element. And actually, people against this decision always says like, yeah, they were building all this with the river and stuff because they wanted to go to the animals, and that's the way the judges we have. They just have this agenda, and now they're going for the animals. And so we said, yeah, there's another component of nature, and this component is animals. And therefore, they are protected with animal rights, with nature's rights as well. But animals have different rights than humans. And we said that because we were sure that people are going to start saying, yeah, so now animals have the exact same rights as humans, and they just humanize the animals, and now they think that we are all the same, and what's going to happen? They already gave gay marriage, so now we know what's going to happen. And that's the truth. And that's the truth. They said like, oh my God, they're just going to ruin Ecuador because they already gave gay marriage and abortion rights, and now they're going with animals. What's going to be next? And we were trying to say, okay, animals have their rights, and we are not trying to change the content of the Constitution. We know the articles say persons have, and we are not going to end up discussing all this, the way we should understand persons, but we are going to enter in a new phase. And we, if you read the decision, you will find that the decision talks about all these phases of these historical phases about animals being objects. Afterwards, the welfare of the animals, you can use them, but you have to be kind with them. And then as objects of protection, which is Ecuador was there before as well. And then just this idea of animals being sentient beings and having feelings and being able to suffer, and started to talk about the nervous system of the animals as part of what makes them different. And then all these amicus were really crucial for us. And I'm going to come back with that because I want to make a recommendation about it, but that's why I'm making my point through these amicus, because they are really important for courts. And we really need for people to help us, because we're not supposed to know everything. We don't know everything. Sometimes we know nothing, but we are still there. And when someone in this morning said, like, judges must do what is right, I was thinking, yeah, we didn't know anything at all, but we knew what was right. And that's what took us to this path. But when we started this path, we actually didn't know where it was going to take us. And we actually weren't sure how to say it and what to say it. And it's a difficult path, and you have to be courage, but you need to have some support. And people is that. And friends of the courts are that. And so we said that, okay, animals should not be protected only from an ecosystemic perspective, but they have their own individuality, and they, as a nature, has an intrinsic value. And so we said, okay, the demands of these beings, living beings, should have another classification. Let's not talk about persons and corporations and whatever. They have to have their own rights, and they have to have their own legal protection. But for that, we need to use these two principles that are really new in Ecuador, that are, first, the principle, interspecies principle, which means that you have to understand their needs and to understand what they are. It's not the same to have a bear than to have an elephant, than to have a lion, than to have a dog. They are all different. And so you have to use this principle to understand what needs and what rights does any of the species have. And then you have to take into consideration as well an ecological interpretation of it. And this ecological interpretation means knowing the circumstances, knowing the species, knowing the interaction it has with other species and with the same, the population of the same species. And this was really hard because we had to find a way to say, okay, there is nothing about this in Article 71, 72, 73, 74, but it doesn't matter. The Constitution has all the rights, and even though it says persons, you can use them if you have an ecological interpretation and an interspecies principle. If you use that for an interpretation, you can end up finding that it is possible to protect animals through other rights that are not in that list, that is not an exhaustive list, that we can open up that to make sure they have the rights they deserve as sentient beings. And then we had a huge problem. When we were discussing this, maybe I don't think we would have gotten the votes, because people were saying in the court, and the judges especially, were saying like, okay, how far are we going with this? So this is Estrellita, this is a monkey, but what about dogs? What about my next dinner? I'm worried about this. I'm not willing to go that far. And so if you read the decision, you will find that everywhere it said wild animals. And we are talking about wild animals in danger, which makes it more closed. And this has two reasons. The first one, because we have been really into framing the cases by the facts. And we did this because the Constitutional Court, the composition before us, used the cases to say everything. It was a simple case with two parties, and it ended up saying whatever about Russia and Ukraine's war. It was the perfect way to say whatever you want to say. And we were against this. So when we came to the court, we said like, okay, this court is going to talk about only the facts in the case, and we're not going to go around it. And as Susan Bauer says, you don't have to fall into the temptation to try to say it all, because that's not the way. And you have to go baby steps. So we said, okay, we've been saying this for 4 years, and now comes Estrellita, she's a wild monkey, and now we're talking about all the animals. So some judges were really strict. We're saying, we are talking about Estrellita. And Chorongo monkey Estrellita, no one else. And so that's why you will find some, and I'm sure that's one of the questions you may have, why only Estrellita? And is it possible to open that up to other animals? And so the court said it in these words: wild animals such as Estrellita can be and must be protected by rights of nature. And the court also said, if we can put the rights of animals together, we will have at least 6. And we have the wild animals have right not to be hunted, fished, captured, to free development of their animal behavior, not being transferred to human environments and forced to adapt, no transformation of wildlife into pets, right to life, right to integrity or well-being. And at first, it just talked about integrity as a physical thing, but you will see that later on, when reviewing the case, it opens up to psychic integrity as well. So we said this about wild animals here, but we already gave a huge catalog of new rights, specified rights for animals. And even though some of you may think it's not enough, well, it's a baby step, but it's really good for wild animals. And as I was talking to Eva earlier this morning, oh my God, don't do that to me. He's only given me 2 minutes. The thing is that the context in Ecuador is different. We are not that worried about huge corporations because we don't have them. Our concerns are more like wild animals, the rainforest, that's the petroleum and mining things, and the environment, especially for wild animals. So this was really good for Ecuador. But we had a problem. And here's another slide to make you think about the Ecuadorian context. And that might be challenging with some things we've been hearing the whole day. Because this decision not only talks about these rights that we had before, but also talks about interaction with humans. And this was a catalog, this was a chapter of the decision asked that maybe the first drafts didn't have, but it was important for some judges. Why? Because they said, okay, we cannot forget that domestication and hunting and alimentation, feeding the society is part of this. And we're not ready, we're not there yet. We don't even have that many vegetarian and vegan restaurants in Ecuador. You can even find like maybe one shelf with this kind of products in the supermarket. And now we're gonna say what? So this was part of it, and this was part of Article 24 that we talked before, and we said, okay, we have to recognize that humans are predators as well, and that if they hunt, it's legitimate, and if they eat meat, it's legitimate, and if they use as domestication, as companion animals, or if you're using animals in the farms, whatever, that's legitimate. If you use the criteria, or you meet the criteria the court is given. And this sent us a little back to the first historical moments I was talking about, like maybe more of a welfare of the animals, and and some people have said to me, like, you go so far with some parts of the decision, and then you just go back and say, like, you know what, the domestication is really good, and you can keep killing animals, it's okay, just be nice. And yeah, I know this can sound some contradictions are there, and I'm completely aware of that, but remember, we're not perfect, it's our first time, and besides, we have to be proportional court. So we are trying to be cautious, and we have to be a little bit conservative in that decision to be growing by the time. And please give me 5 more minutes. I'm the best part. I know you're all tired. I'm sorry, I have so much to say about this. These are the facts. I'm sure you know all about them already. So you might know that Estrellita came to this house, Anna's house, that's the name of her, when she was just 1 month old. And she lived there for 18 years. Suddenly, someone complained and told the authorities there was a wild animal living in the city, in an apartment. They have a terrace, and she was living there. So someone called for the authorities, and Estrellita was restrained and sent to a zoo. The sad part is that even though Estrellita was totally humanized and she was part of a family, when she got restrained, she died. And the authorities say it has nothing to do with them. It is because all these problems she had before, but she only lived like a month. It was in September they caught her, and she died in October. So she just lasted for a month there. And the owner filed an habeas corpus, but what she asked at first was, please give it back to me. She's not supposed to be there. That's not the well-being for her, because she's been always with us and she's part of the family. She has to come back. And then during the hearing, the authorities say, oh yeah, you know what, she died already. And the plaintiff said, okay, if you're not giving me back the monkey alive, I want the corpse because I want to bury her. And the authority said, of course not, because it does not. And both judges, first and second instance, said they denied the habeas corpus. And when the court had to analyze the case and review the case, we analyzed 3 stages. And this was really hard for us because we have different feelings for every of it. And we are not judges, but we had an understanding of each of these in a different way. First was destruction of the animal from the natural habitat. If you see, it was kept in an urban house, she was humanized, there was no intention to reintegrate her to her habitat. Her nutritional needs were not covered. She was not in a good health. She didn't have a good health. She had problems with the skin, the teeth, the malnutrition, and the court said, we can see that her rights were violated by the owner, by the previous owner. But we cannot declare that because it's an habeas corpus that has nothing to do with the previous holder. So we cannot declare that, but we're gonna say something about it, and we established some standards about, and I'm just gonna show you, and you can find them on the decision, parameters regarding to the conditions of keeping animals when you have an ex situ conservation. And it was very important for the court that even though we couldn't declare the violation of the Estrellita's right for this, we did wanted to let them know that we regretted that what happened. Then it came the restraint of Estrellita by the authorities, and after all, the custody of Estrellita in the zoo. And we analyzed the restraint that was part of the habeas corpus already, so we had more space. And the environmental authorities didn't examine the particular case of Estrellita. They never took into consideration that when they executed the restraint, she was an animal that has never been outside an urban space, and that the only family she had was human. And they didn't have a transition process to make sure she will be okay. They gave custody to a zoo, and they had it in a jail, and they have it in a cage that looked like a jail actually. And this no transition stage that was not evaluated and that was not considered violated her rights to integrity. And the court said not only integrity as a physical thing, but as a psychic thing. And maybe it had all to do with her death. And then, of course, we made a rule that every restraint and seizure and immobilization of wildlife has to take into consideration all the circumstances and has to have a comprehensive study. But the thing didn't end there, because the complainant said it is the zoo fault as well, because I'm sure they didn't treat her right. And so, because Estrellita died under their care, and we knew that it was not caused by natural things, but the authorities had all these reports saying that they had nothing to do with it. And I put a phrase we say in Ecuador. It's totally me, not the court speaking right now. But I have no evidence, but I don't have doubts. Every Estrellita died because of the restraint and because of the zoo management. And in that order, the Constitutional Court declared the violation of integrity and life of Estrellita. But most importantly, we held a lot of criteria about jurisdictional guarantees for animals protection, and we made it clear, even though the Constitution says that nature and animal rights have two dimensions: some substantive, holders of rights, and the procedural one. That means that we have the right to go to administrative and jurisdictional organs to pursue that justice. And that all nature rights, including the ones that are not specifically in the Constitution, are justiciable. And that after Estrellita, obviously, animal rights are fully justiciable too. And in this part of the decision, it says nothing about wild animals. So, what is for sure is that any person can exercise the jurisdictional actions on a constitutional level. We also have, obviously, criminal law and other administrative measures to avoid cruelty and protect animals. But this is on a constitutional level. And there is no limitation on which guarantee you are supposed to use. In Ecuador, we have the constitutional guarantees are 5 or 6, and they are for different rights, and that includes habeas corpus, as well as the action of protection. That's called for the general complaints you might have from violation of rights. And the court said, okay, here I'm not going to say if the habeas corpus was the way of protecting Estrellita, because in this case, Estrellita is already dead, and I can really, as the judges said before, we cannot give the corpse to the lady. And the other thing is that the plaintiff was asking something illegal, because she wanted the monkey back, and she cannot give her, and we know that it was not in good conditions, and she has no way to protect her, and that's captivity as well. So you can never give the habeas corpus, because the pretension, because what she was asking, it's illegal. So she's not going to get it. But the problem is that we never said if the habeas corpus is permitted for animals or not. And I think the Constitutional Court did this on purpose as well, because we didn't have to get there, that it was going to be harder on the media and everything. But we said, okay, in this case, it's not that. But see this, judges must analyze each case, its particularities, and purpose of each specific guarantee to determine which of the rights and which of the guarantees is useful for that animal. So it opens a huge door saying like jurisdictional guarantees are good for animals, and you can use whatever it is needed to protect the animal. But in this case, it was not the habeas corpus. Why? Only because Estrellita was dead and the pretension was completely illegal. But that put us in a difficult thing, because we had to repair, and we couldn't repair. And we said like, what if Estrellita was alive? And we asked ourselves that a lot of times and during the discussions. If she was alive, what are we supposed to do? And the decision doesn't talk much about it, but says, okay, judges, you are supposed, when you get this kind of actions, you are supposed to find the better reparation mode, and that includes maybe not giving what the plaintiff wants, but you have to think about sanctuaries, you have to think about reinsertion. We know it takes a lot of time, but you should try. We know that the animals are imprinted already, but you can work something out. And in this case, we know that if she was alive, it was going to be hard, because we had to deny the habeas corpus, but we couldn't let her be in the zoo or receiving the treatment she was receiving. But the court couldn't say that. And well, that's I promise I'll just finish up. And that's the case in Estrellita. As conclusions, these are just me already. It is important to say that nature rights are the ones who open the door for animal rights in Ecuador. Without nature rights, I'm sure I wouldn't be here today. And our way to get in that was nature's rights. And so maybe thinking about environmental law, thinking about nature rights, might be a good approach when the strategies are needed. So maybe think about it. The Constitutional Court interpreted the Constitution and gave content to that Chapter 7. And this was pretty radical, because we said, and some people said, okay, you now just change the Constitution. It never said something like that. You just incorporated new articles and you are way ahead of your obligations. But the Court gave content to Chapter 7. And now the problem is implementing this. And we have trouble with this, not only because judges are not implementing it necessarily, but because we have other cases now, like dogs or cats or cows or other stuff, that they don't belong in Estrellita's case. It's not the case law. You know, you have to apply the case law by the facts and everything, and they don't get it. But some judges are giving habeas corpus, some others are denying it. And so the implementation of the decision, it's been really hard. The appropriate reparation is also a really difficult process. The court has had many problems trying to find a good reparation, not only for this, but for all environmental things. It's not about money, it's not about restitution at all, it's really complicated. And finally, I think we've been receiving some new cases, but to tell you the truth, the plaintiffs are not always the best ones, and people, we don't have that many organizations, animal organizations or ONGs in Ecuador working for this. So it's regular people doing this. And for example, in Estrellita, the amicus were really important for us because they gave us another spectrum. But the only way to expand and to keep working on jurisprudence is getting cases. And therefore, we need people to involve in that. And that means lawyers, that means judges, and that means the society. And that's what we are missing as well in Ecuador, to keep going and to keep working on animal rights. I'm gonna leave it like that. I'm so sorry to take in so much time.